All right. So I think we can get started. I know there's still a few more people trickling in, but I'll just start in on the administrative side of things. Thank you everyone for coming. My name is Taylor Kohler. I use she, her pronouns. I am the Policy and Program Staff Attorney with the Center for Human Rights and Constitutional Law. Our training that we are all here for today is the Supreme Court Shadow Docket, Justice Obscured. Um, just as a heads up, the PowerPoint will be sent out to everybody, as will CLE certificate, certificate of attendance, your certificate of attendance. I will try to get that out as soon as possible. But if for any reason you haven't received it by like the first of the year, it should have come out by then. Please feel free to send me an email. My email is at the end of this presentation, but it's also in all the invites that you have received. So you can definitely reach out to me. So with that, I think we can get started. So, just to preface, this training came about because while everyone does our wonderful registrations, one of the questions on our form is always what can we provide a training on? And I continually kept seeing questions pop up about what the heck is going on the shadow docket. Like, what is it? How is it operating? And so I decided that we would have this training because clearly there's an interest in it, and the shadow docket, it has growing importance. Um, but I think just to preface this training isn't necessarily about the exact cases or the exact, law or decisions being made in any singular shadow docket case. Um, I really wanted this training more to be a chance to look and see the patterns that are happening and broadly what is going on so that we as practitioners can be more aware of kind of how this landscape is shifting and how we can think about it in our own practices. Um, so that's just something to think about as we go through that I'm not going to try to focus in on any specific details to the extent that I'm trying to show patterns broadly. Um, so with that, we will get started. And just as a reminder for the people who just kind of joined in, any questions can go into the Q&A rather than the chat today. So here's our agenda. We're going to go through what is the shadow docket, why do we care about it now? We're going to look at the historical use of it, the birth of the modern shadow docket, discussing kind of this explosion that we've had. And then we're going to go through some different sets of cases to look at the patterns. And you'll notice here I have death penalty, election disputes, redistricting, and religious liberty. You'll notice that I didn't include immigration cases. And that is because typically we get a lot of immigration practitioners in our webinars. And I think a lot of you probably are paying deep attention to those. And there's a lot of other trainings on those decisions. And so I wanted to help you see the patterns that are happening perhaps in areas of law that you're not paying attention to, but that are shaping the way the shadow docket is working and thus impacting different fields. So that's kind of that selection. And this is the cases that I choose to go through. They're not all inclusive. Obviously, there's whole other areas, but these were just some that I think kind of show what's going on. And then we will get to kind of what is the precedential value um, of the decisions made on the shadow docket, and then how should practitioners think about reacting to those developments. So firstly, we start off with what is the shadow docket? And this term, the shadow docket, actually came to be in 2015. However, the shadow docket has been around and it encompasses broadly, if you think about it in a very broad sense, all the orders and decisions that the justices hand down apart from their written opinions in full merits cases. This is things like orders granting and denying cert. It's orders granting or denying emergency relief. It can be as simple as orders on due dates for briefs. It's essentially all of SCOTUS's output that isn't rulings. It's all of those things for which there isn't a full thought out, opinion fleshed out. That being said, The popular definition, the way we talk about it today, um, with kind of the explosion, is specifically looking at the emergency docket and those applications seeking immediate interim relief from the court. And these are the decisions that are contentious and controversial. I don't think when people are talking about, the shadow docket, they're talking about, orders on due dates for briefs. Um, Although I will say that orders granting and denying cert on their own can be, highly impactful. Those can be contentious. But in general, what people are talking about is the emergency docket. And there's a strong belief right now by a lot of practitioners, by the lay public, by people who study the Supreme Court really intently, that it is being used to obscure and to bypass briefing and hearing. So the core elements of what makes something a shadow docket decision, um, in the sense that we're going to talk about it in the popular sense, we're going to focus on that, is that it's handled on an expedited basis and that the case hasn't been able to fully progress through ordinary procedures so that the Supreme Court could issue a regular merits opinion. And there's limited briefing, typically no oral argument, and the decision that comes out has little to no legal reasoning, analysis, or explanation. You get these really short, sometimes a few pages, sometimes a few sentences, a sentence, um, issuing that decision. And they're unsigned per curiam, and they lead to a lack of clarity on which justices are in the majority, minority. You're left to guess this based on if there's dissents and if there's any concurrences to the majority opinion. Um, and the critiques of the shadow docket then is that these decisions fail to resolve the important legal issues in reasoned opinions which have been informed by complete briefing and argument. And this is particularly true as we've seen really important cases with massive impact move to being decided on the shadow docket. And they risk premature decision making, right? We are making something before a decision before it has been, fully briefed and had a chance to kind of percolate through the courts in a typical manner. Um, Really critically, and particularly now, these shadow docket decisions are providing insufficient and confusing direction for lower courts. Kind of this question of, are they precedential? Do we have to follow them? How does that work? Um, and all of this together is undermining the court's legitimacy, and the rule of law. And that on its own is important regardless, I think, for most of us as practitioners, we believe that's important regardless of what the outcome is. So that brings us to the question of what's the fuss? Why now? Um, since January of 2025, SCOTUS has issued 23 decisions on the shadow docket concerning administration actions, so focusing on those brought by the administration. And they've ruled for the administration at least partially 20 times, and only three of those have ruled against the administration. Seven of those decisions don't have any written explanation. They just exist as a decision. And in the first 20 weeks of President Trump's second administration, he's made as many shadow docket applications as the Biden administration did in 4 years. The Biden administration made 19 applications. But both of those numbers are higher overall when we look at this explosion. The Obama and Bush administrations combined made only 8 requests in 16 years. And the administration won only 50% of the time. And in all but one decision, the Supreme Court spoke with one voice. There weren't any dissents. And this suggests that at that time, those decisions were not contentious, controversial, things that really did need that full merits review. And so you're seeing this upward trend, and that's occurring from the Solicitor General, um, making more applications, choosing to do so. And so even though this is something, we started to see with the first Trump administration, Biden absolutely continued to push to have more, emergency docket decisions. And the second Trump administration is increasing that even more. So this is just a trend, a pattern we're seeing in general now. And here is, a graph showing kind of this trending expansion of emergency applications. In particular, if you look at the bottom, I think it's kind of an orangish color, you'll see the line labeled president, and you'll see those applications going up dramatically. It's almost flat up until about 2017, and then you start to see this spike. And also you see a rise in other petitioners bringing those emergency applications. So you can see very clearly this trend, this upward trend. This chart shows the contentiousness, I think, of these decisions. You start to see where there's disagreement and dissents. And so you see those dissents continuing to rise as we see these greater splits, suggesting more and more need for full briefing. It's not necessarily a simple decision. So just to kind of go through the historical use of the shadow docket, through the 1970s, individual justices, the circuit justices, were hearing emergency applications on their own. And that individual justice would typically actually have oral argument in chambers, and then they signed in chambers opinions that did have reasoning. It wasn't necessarily a, a full merits type reasoning that you see in a full opinion, but there was reasoning and it did occur, and there was a chance to have that oral argument, to have a bit more briefing. And there's actually, I think there's a really famous case now, I'm forgetting which justice it was, but the attorneys like went and trekked through the forest, to get to one of the justices who was at like his hunting cabin, and they had oral argument like in his hunting cabin, and then he took a decision and like pinned it to a stump. And that is just emblematic of what it was before. It was these individual justices making these decisions, and there was a chance for some engagement there. But in the 1980s, there were some changes to the court behavior overall. The summer adjournment ended, and this created an opportunity for the emergency applications to be resolved by the full court. And at the same time as that happened, death penalty cases were really growing. And so they started to be referred to and resolved by the full court rather than just the circuit justice. And when this happened, the practice of in chambers oral arguments just died out and it isn't replaced. So you don't get more procedure added in through having the full court weigh in. You actually kind of lost procedure. So prior to 1980, it was rare to have orders of the full court denying or granting applications for emergency relief when a circuit justice hadn't already taken an action on it, and then the losing party sought full court review. So you just see this big shift in the 80s. And the birth of the modern shadow docket essentially revolves around capital punishment cases. And this is because in the 1970s, there were changes to how capital punishment worked, both in law and through the Supreme Court. And it created a new era of procedural steps and substantive requirements for these capital cases, which then created an uptick in requests for emergency relief. You'll see in 1960, there were only four applications for stays of executions, but by 1983, that it ticked all the way up to 83. So essentially, this combination of factors and changes really just increased the Supreme Court's number of emergency stays for execution that they were doing. And what was really important here is that the justices were really divided over the death penalty. And this is part of what led them to begin resolving it as a full court. They didn't trust each other to solve individually, so they wanted to solve as a whole. And like I said earlier, we ended up with less process here, and less explanation. Um, so that gets us to the current explosion that we have. Um, just some things to muddle over is that uh, the Trump administration's Solicitor General in his first administration sought emergency relief from SCOTUS 41 times. And the Solicitor General's advanced new theories that justified the Supreme Court's authority to grant emergency relief. Um, and this worked. The justices granted at least part of the government requests in 28 of 36 of the applications that resulted in up or down decisions. And what was really important is that they granted, these requests without tying themselves to principles that they'd be bound to apply for future precedents. So they weren't creating these principles that were binding for themselves. Um, and at the same time, after the travel ban ruling that I'm sure so many of us are familiar with, almost all of those decisions came with no written opinion from the court. So you're just getting the decision on its own. Um, and what's really important is as this is happening at the beginning of, during the first Trump administration, is that the government was testing out litigation strategies that ended up setting precedent for efforts to change the law on the ground without changing the law on the books. They were winning by not losing. Um, and that's a strategy that was really actively being pursued through the use of the shadow docket, and that's something that's still happening. So now we kind of begin our exploration of kind of the shadow docket through the death penalty. And that is because the Trump administration reinvigorated the federal death penalty. And there were 13 federal executions in just a 6-month period at the end of his first term. Um, and the Supreme Court, using the shadow docket, ended up clearing the way for all of those executions. And what's really critical is that seven of those 13 actually wiped away the lower court stay or injunction. Um, and only one of those actually had a full majority opinion that was written. The cases that we're going to go through, you'll see they affected substantive change to procedure without really changing the legal doctrines or the constitutional questions, those underlying things. Even though it was just procedure, the real world result is that lower courts read the shadow docket decisions as substantive judgments, which affected death penalty challenges. In practice, this changed who was able to get, um, stays, uh, and this meant that people died. So in practice, there's a massive result. It's not just procedure, the impact in the real world is there. So, the first thing to say about the death penalty cases, though, is they're a bit different because typically the decisions are only impacting one individual, not entire classes of people. Um, and they were already like the amount of applications were already decreasing by the time that Justice Kavanaugh succeeded Justice Kennedy in 2018. And there was kind of an assumption that the death penalty cases would get even less attention. But that didn't happen because very quickly after Justice Kavanaugh joined the court, the justices were kind of received a lot of attention because they had two cases, Dunn v. Ray and Murphy versus Collier, um, in February and May of 2019, where they were perceived as having inconsistent treatment of requests from death row inmates with a different religion. In Dunn, Ray was the inmate who was on death row, and he had challenged a state policy that allowed Christian chaplains in the execution chamber, but not a Muslim imam. The Court of Appeals had blocked the execution, but the Supreme Court stayed that. There was no majority opinion. Um, there was just a concurring opinion, and they accused Ray of waiting too long before requesting relief. But just 8 weeks later, Murphy, who was a Buddhist death row inmate, challenged his inability to have a religious official in execution chambers. Texas allowed only Christian and Muslim officials. And this time, SCOTUS grants the stay of execution. Again, no majority opinion that even tried to explain the differential treatment. Justice Kavanaugh appended a small footnote that said that Murphy had made his request in a sufficient timely manner. So you get these two cases right at back to back, completely different, decisions, and nothing to really go on. Um, 4 days after the Murphy case, we have Bucklew versus Precythe, I believe is how you say that. And this was a merits case about lethal injection protocol. So the substance was on the method of execution. It had nothing to do with timing. But in the majority opinion, Justice Gorsuch went out of his way just to question the propriety of emergency relief in favor of prisoners. And he said that last minute stays should be the extreme exception and not the norm. And then he invoked the decision in Ray to suggest that prisoners who brought claims close to their execution date, where they could have been brought earlier, could be grounds for denial of a stay. Um, Justice Sotomayor pointed out that this was completely irrelevant to the case. The case was a case about, method of execution, and explicitly said that if these comments, were taken as a new governing standard, they would reinvent established law. Then we have shortly afterwards Barr v. Lee. We are now back to a shadow docket case. And at issue was a single drug protocol that the federal government had decided to use to carry out federal executions. The district court had enjoined 4 different executions due to this protocol out of constitutional concerns. Um, and the judge went out of their way to explain that the proximity of that ruling to the impending execution dates were none of the prisoner's fault, but that the government had been trying to expedite these executions, even while the prisoners' legal claims and untested legal claims were pending. So really went to great lengths to say this. So the Court of Appeals refused to issue a stay and set an expedited 11-day briefing schedule. So it's going to move really quick. But the government asked the Supreme Court to vacate that injunction, and they did. And in doing so, they wrote a very short 3-page opinion. They didn't resolve the Eighth Amendment claim, and they just complained about later rising challenges to impending executions and pulled the language from Bucklew about late-minute stays and essentially turned it into the practice. And they picked that, put it in there, and that led lower courts afterwards to apply a presumption against all end-stage claims, irrespective of, the individual's fault for those. So here we have this language being put into a shadow docket case that impacts the lower courts. They started applying it. And the lower courts, felt that the ruling made clear that execution could proceed so long as a constitutional challenge hadn't been decisively resolved in favor of the prisoner. And the Lee case just cleared the way for multiple other executions that lower courts had blocked. And so after this, there was a series of shadow docket decisions that taken together kind of created this broader substantive change to capital case procedure, even without changing the underlying substantive law. So again, we didn't change the underlying substantive law, but the procedure changed, and the procedure did have an impact on individuals and the ways that lower courts acted. Um, but then we get to this last case. This is the last federal, US v. Higgs. It was the last of the federal executions under the Trump administration. And typically, this is a really interesting one. So, the federal death penalty statute requires a sentence to be carried out according to procedures in the state in which the federal court sits. Um, and Higgs had been sentenced in Maryland prior to the state abolishing the death penalty. So when his execution is impending, the government asked the district court to go back and amend the judgment to use Indiana's laws. And the district court, Indiana had death penalty laws, and the district court said it lacked power to do so. So the government appealed to the Fourth Circuit and at the same time sought expedited merits review with the Supreme Court. The Fourth Circuit agreed to expedite and hear the case really quickly, but the Supreme Court moved even faster and they granted a writ of cert before judgment. And they remanded the case to the district court, telling it to designate Indiana as the relevant jurisdiction. It also vacated the stay of execution. Now, this was really interesting because cert before judgment is supposed to be reserved for truly extraordinary cases. The Supreme Court's own rules say it'll only be granted upon a showing that the case is of such imperative public importance as to justify deviation from normal appellate practice and to require immediate determination in this court. And you know this is really rare because between August of 2004 and February of 2019, the court had not granted a single cert before judgment even once. It's not something that is used typically. For all purposes, this case shouldn't have met that high standard for cert before judgment. The statutory question impacted a very small subset of cases. There's very few federal death penalty cases left. The Fourth Circuit was moving extremely rapidly. But the court acted summarily. They didn't even conduct an expedited plenary review or hand down a lengthy opinion. There was no merits briefing or argument, which is really interesting because in 98 years that the court had had authority to grant cert before judgment, there were no prior instances in which it did so just to issue a summary ruling on the merits. So the question then is why did they do this? Well, the only thing that's left, we have no real opinion. The timing, 5 days later, President Biden would be sworn in, and they knew he was opposed to the death penalty. And the Fourth Circuit was set to hear argument 2 days after that. And so that's what you're left with. And this is why we get this question of, undermining that legitimacy in these death penalty cases. But again, if you look at all of these death penalty cases together, you see the court was really shifting procedure and making change, which was impacting how lower courts acted, impacting people's lives, literally taking people's lives away. All on the shadow docket. So I think you can see here, you're starting to see that trend of impact. So now we move to election disputes. And the shadow docket election disputes, the whole docket really starts with a shadow docket decision from 2006, Purcell v. Gonzalez. In 2004, Arizona voters approved a ballot initiative that imposed ID requirements for in-person voting. The DOJ approved pre-clearance for it. And in 2006, Arizona voters sued, claiming that they were a violation of the Voting Rights Act and were unconstitutional. The district court denied the request for an injunction with no explanation. Um, and then the challengers to this asked the Ninth Circuit to enjoin the pending appeal. They wanted to prevent Prop 200 from being enforced, at least for the upcoming 2006 elections. Um, so the Ninth Circuit did. They enjoined those voter ID laws while they were considering the merits. Arizona didn't like that, and they asked the Supreme Court to stay that injunction and put Prop 200 back into effect for Election Day. Now, what's interesting here is that rather than just granting the stay, the Supreme Court treated the state's emergency application as a petition for writ of cert. They granted it and summarily vacated that injunction. And they wrote about a 5.5 page opinion, which articulated something that became known as the Purcell principle, which is essentially that to avoid confusion among voters and election administrators, courts should not change the rules governing elections as election day approaches. That sounds theoretically acceptable, but it doesn't explain when it's too close. There's no bright line rule. And it also doesn't, the case didn't explain why traditional factors, which would balance and assess harm, were insufficient. The pre-Purcell analysis would have focused on the actual likelihood of harm to voters if there would be voter confusion, rather than the Purcell principle kind of created this general presumption that all late changes to election rules will confuse voters. Um, Essentially, what is interesting is this Purcell principle really invited bad behavior by local and state officials because it kind of implied that you could get away with unlawful changes so long as you adopted those late in the game. And this was particularly true after the court gutted pre-clearance requirements in Shelby County v. Holder. Um, so this shadow docket decision becomes extremely influential. We have this new principle that's set out, and it starts to govern all the election disputes that come afterwards. Um, which takes us into kind of the COVID era with an impending election, and we start to get election disputes, in on that emergency docket. Um, and these cases start to show a really inconsistent application of the Purcell principle. Um, in the RNC versus DNC case, a federal district court ordered a state to extend their deadline for receiving mail-in ballots, um, and for the mail-in deadline. They extended both of those because of COVID, basically. The RNC asked the circuit court, the Seventh Circuit, to stay that ruling. And the Seventh Circuit left intact. They stayed part of the injunction, but left the extension of both the mailing and receipt deadlines intact. Supreme Court heard this and in an unsigned 5-4 ruling, put that original mailing deadline back into effect one day before the election. They went out of their way to take, no position on the merits, but they utilized Purcell to justify their decision. And, essentially they said, all of this happened too close to the election. Voters will be confused. Justice Ginsburg called crap on that and said that was highly ironic considering, the extended deadlines didn't really pose any risk to the voter confusion, but also that it was the Supreme Court's own decision that would be causing the confusion. They made this decision one day before the election, and they moved that postmark deadline back up to Election Day. What's particularly, the conventional balancing of equities test here would have, probably resulted in a different result. But that's how they use the Purcell principle in this case. 3 months afterwards, in Resor, you get the Florida case regarding the convicted felons, the the constitutional amendment that had attempted to re-enfranchise them. Um, the governor, Florida governor and state legislature had interpreted that amendment as only applying to those released felons who had cleared all their fines and fees. And these interpretations were challenged. The federal district court had blocked those interpretations and held that they were likely unconstitutional. Um, and the 11th Circuit stayed the injunction 19 days before the voter registration deadline. Um, so the Court of Appeals kind of changed the rules with no explanation for why it was doing so right before that voter registration deadline. You would think here, if you apply Purcell, that you'd have a different result. So the plaintiffs, asked the Supreme Court to lift that Court of Appeals stay, invoking Purcell, and in a one-sentence order, the Supreme Court denied that. So you have this big inconsistency on Purcell right here. Again, this principle is guiding these decisions coming out of a shadow docket decision itself, and you're not even getting any explanation for these different decisions. Right around here, we have Justice Ginsburg passes away, and Justice Barrett replaces her. And you'll see here the next thing we have the next case, the Andino. The ruling in this case, just to keep us moving, came 46 days before the election. And yet the Supreme Court, granted the stay of the injunction. And they created a really confusing rule. They said ballots cast before the stay, and received within 2 days of the order would not be rejected because this is over signatures on ballots. But after that, it would change. And so no majority opinion on this, but again, invoking Purcell. And to keep us moving, you'll see what you get out of these election dispute cases is a clear subjectivity of Purcell and its ability kind of to crowd out competing concerns. But for everyone paying attention, what this looked like is that these rulings tended to benefit Republicans and hurt Democrats. And that partisan trend was kind of the through line. And again, this is because whether there was a good faith explanation, there's no decisions to show that. There was very little new law made through the election cases. But still, it's undermining the legitimacy and having really big impacts. Which brings us to redistricting. Allen v. Milligan is the Alabama redistricting case, and I'm guessing a lot of us have heard about it. But essentially, Alabama adopted new maps for its 7 U.S. House seats after the 2020 census. And the federal district courts essentially blocked those maps, saying that they violated the Voting Rights Act due to vote dilution. And they ordered Alabama to redraw the maps with the majority-minority district. And they said there was plenty of time for them to do so. This was 9 months before the 2022 midterm and 4 months before the Alabama primary. Alabama didn't like that, appealed up, and applied for an emergency stay to freeze the lower court ruling so that the state could use those invalidated maps. By a 5-4 vote with, again, no opinion or really any cursory explanation for the majority, the court granted those stays. Again, no majority opinion, and they promoted the Purcell principle and they called it a bedrock tenet of election law. What's interesting here is that this Purcell analysis suggests that there's nothing that could have been done to stop Alabama from using the unlawful map for at least one election cycle. And this is because they had sued, the challengers had sued the day it was approved, which was a big shift from Voting Rights Act existing precedent. Um, Chief Justice Roberts wrote a dissent in this case, and he criticized the majority for blocking the district court's ruling, and said that the lower courts had properly applied existing law in an extensive opinion with no apparent errors. Um, and the dissent was, of course, slammed all of this, saying that it would rewrite decades of this court's precedent, and that the court was using the shadow docket to signal potential changes. The rub in all of this is that not only did Alabama get to go use its unlawful maps, but the Supreme Court did end up hearing this case on the merits in January 2023, and they affirmed the district court and found the map to be a Voting Rights Act violation. So this just it looks bad. Um, and it had a real impact, right? It changed seats. Um, Additionally, lower courts responded really heavily to Allen v. Milligan. A Georgia district court actually refused to enjoin Georgia's redistricting map. It had the same violations as Alabama's. And it said that the court said it would be unwise, irresponsible, and against common sense for this court not to take note of the Allen v. Milligan decision. So they didn't even enjoin it. Again, unlawful maps happening, but they responded and reacted to the shadow docket decision. Um, just um, We also have another case in Louisiana, um, where the Louisiana District Court blocked Louisiana's proposed congressional maps, again for violating the Voting Rights Act. But the court was aware of the Allen v. Milligan decision, and the district judge took great care. They wrote a 152-page opinion, um, distinguishing, kind of distinguishing from Allen v. Milligan and the Georgia District Court case, and really saying why it was appropriate to issue an injunction. The Fifth Circuit, conservative, right, refuses to block that ruling and wrote another 33 pages of its own saying why the injunction should be left in place. Again, the Supreme Court intervened and put these blocked maps back into effect. No explanation for why those 152 pages from the district court and 33 pages from the Fifth Circuit were incorrect. All of those cases taken together, the redistricting cases, guaranteed House seats that likely would have been for Democratic candidates, safe seats, and gave them to Republicans. And again, those maps ended up being, problematic on merits later, but the impact, the real impact was there. And then the court went even further with its redistricting in the Wisconsin Legislature versus Wisconsin Elections Commission. The Wisconsin Supreme Court had essentially had to solicited and looked at maps from both the legislature and the governor, and they had adopted the governor's proposal, which would have created a majority-minority black district. The governor believed that it was necessary to satisfy the Voting Rights Act. The state legislature had asked the Supreme Court to stay that decision, or in the alternative, to grant cert and agree to resolve on the merits. The Supreme Court, another unsigned opinion, they granted cert, but they summarily reversed the Wisconsin Supreme Court and came up with a new rule and said adoption of majority-minority district required state actors to show that it was required. This there's no existing precedent for this. Um, and the Supreme Court didn't need to answer this question. They could have simply waited for an actual plaintiff who would have brought an Equal Protection or Voting Rights Act challenge. Um, the discussion of why did the Supreme Court do this is that, if they wanted to be faithful to the Allen v. Milligan case and Purcell, they would have had to allow the governor's map for at least one election cycle because by the time a proper plaintiff brought it, it would be too close to elections. Um, so again, they're really pushing and making, you know, operating outside their own precedent on the shadow docket here, um, as well. Taken together, all of these redistricting cases, show that the court was intervening selectively and inconsistently. They essentially made new law in Alabama case, right? They created something that the lower courts were following, and they were increasingly producing effects in other legal decisions across the country. Um, and the cases appeared, at least, explicitly partisan and had significant real world effect. And finally, we're going to look at kind of these religious liberty cases. And I think this is perhaps the biggest section, um, because you'll see how the court starts to treat them as precedential. For time purposes, I'm going to keep us moving here. Um, but the first case is that's relevant here is the South Bay Pentecostal Church v. Newsom case. It's known as South Bay 1. And that issue was California's, COVID restrictions, and a church challenged those restrictions. Um, the lower courts refused to put any of those restrictions on hold, which meant that the church had to ask SCOTUS for an emergency injunction pending appeal. And traditionally, unless parties seeking emergency injunctions pending appeal can show that their right to relief is indisputably clear, justices lack the authority to issue such orders. Um, Essentially, for relief to be justified, they have to show that the lower court not only erred, but made a mistake really that no judge could have made or should have made. The court hadn't issued one since 2005 or 2015. And the Roberts Court had only issued four since Chief Justice Roberts was appointed in 2005. So they're rare. The court denied the injunction request. There was no majority opinion. However, Chief Justice Roberts wrote a concurrence. He wrote a solo opinion discussing essentially this procedural point about emergency injunctions pending appeal and the stricter standard, this indisputably clear standard. So that all happens in South Bay 1. There's another case, the Calvary Chapel Dayton Valley case that happens. Same thing happens, and they denied that one as well. But then Justice Ginsburg passes away. Justice Barrett succeeds her. And this brings us to Roman Catholic Diocese of Brooklyn versus Como. Again, we have a church suing to challenge COVID restrictions. And in this case, in New York, houses of worship were actually being treated more favorably. And the church claimed that the order singled out religious practice in violation of the Free Exercise Clause. The district court denied request for a TRO, and that district court actually cited Chief Justice Roberts' concurring opinion in South Bay 1. Again, we're seeing lower courts using those shadow docket opinions concurrences. The Court of Appeals also declines to put the restrictions on hold while appeals are pending, also cites South Bay 1. The church applies to the Supreme Court for an emergency injunction pending appeal. Interestingly, by this time, the church isn't actually suffering any harm. The restrictions had been loosened, so there was no harm happening. And still, the Supreme Court grants that emergency injunction pending appeal. The only big difference here is that Justice Barrett joined the minority from the earlier decisions. It's a really short majority opinion. What's interesting is They did not analyze the claims under that indisputably clear standard. And they focused instead on the traditional standard that trial courts use to decide whether to issue a preliminary injunction. They didn't explain why they were doing this. And their opinion focused on whether the church was likely to succeed on the merits and whether it would be irreparably harmed if the restrictions remained in place. Um, Justice Kavanaugh and Justice Gorsuch each wrote separate concurrences, and they made nods towards the most favored nation view of the free exercise clause. Chief Justice Roberts writes a separate dissent. It is only his second time in 15 years writing his own second dissent. And he says that he agrees that New York's rules are more problematic than those from California, but focused on procedure and said it is inappropriate essentially to use the rare remedy of an emergency injunction on the shadow docket. But we have a flip. Following that, we have Harvest Rock Church v. Newsom comes shortly after. Um, what is interesting here is that the lower courts had denied an injunction of, COVID restrictions. They relied on South Bay 1, but this ruling had happened before the Roman Catholic diocese case. The Supreme Court, when they got it, took the emergency application, turned it into a petition on their own, turned it into a petition for a writ of cert before judgment, and combined it to just summarily grant and vacate the lower court order and remand for reconsideration. They remanded for reconsideration of Roman Catholic. Um, we have this Roman Catholic case that was just about New York, decided on a very fact specific case about how, the COVID restrictions were happening in New York, and told California, hey, you need to go look at Roman Catholic. There was no dissent on this, but it essentially implied that the Supreme Court's ruling in Roman Catholic had not just changed the law in New York, but at least had some nationwide impact. The court then did the same thing in two COVID disputes from New Jersey and Colorado. They didn't compel lower courts to block their state's COVID restrictions, but told them to go back in light of their shadow docket decisions. So they were signaling to lower courts that they had changed their analysis, both of the free exercise clause and that those shadow docket opinions had some level of precedent. Meanwhile, in South Bay and Harvest Rock, they went back through the courts in California, and separate district courts concluded that revised California restrictions didn't suffer from those infirmities that had been identified in the Roman Catholic case. So back up to the Supreme Court we go, and the court issues separate emergency injunctions against the new restrictions, but only partial. They block one major prohibition and left two others in place. No majority opinion to explain that rationale, but that's what happens. Following that, the justices start to invoke South Bay 2 numerous times. They start to tell other courts to go, district courts to remand and consider in light of South Bay 2. In Gateway City Church, they even tell them a church was challenging not the broad state of California restrictions, but specific restrictions for Santa Clara County. And Santa Clara County had drafted theirs with the intent to avoid the issues that had been problematic in California's. The Supreme Court enjoined those without any analysis, and they just critiqued the Ninth Circuit and said, this outcome is clearly dictated by this court's opinion in South Bay 2. So we start to see they're using these shadow dockets to instruct lower courts and actually critiquing those lower courts when they don't do a good job of taking, a one paragraph 2 pages, decision. Um, and this all leads to Tandon v. Newsom. Um, Essentially, there were pastors who were claiming that in-home gatherings, the limits on in-home gatherings unconstitutionally interfered with their right to conduct Bible studies. The lower courts denied an injunction. The Supreme Court issued that injunction, and they wrote an opinion um, where they adopted an entirely new interpretation of the free exercise clause. Um, the prevailing understanding of the free exercise clause from 1990 had changed. Um, and they cited for this the Roman Catholic case, and they embraced the most favored nation theory of the free exercise clause. So we have law change here, um, or at least big substantive changes happening. Um, and again, the court took a shot at the Ninth Circuit and said this is the fifth time the court has summarily rejected the Ninth Circuit's analysis of California's COVID restrictions on religious exercise. Um, Again, saying, why weren't you following our shadow docket decisions? So this case really broadcast that even unsigned and unexplained orders were to be treated as precedent by lower courts. Um, so this decision, not only did it adopt the most favored nation reading, um, which was new, but it didn't use the indisputably clear standard either, which is required by the statutory authority. So this leads us to, as we wrap up here, what is the precedential value? Theoretically, shadow docket orders really shouldn't be viewed as binding precedent. There's no oral argument, there's no briefing, there's really no opinion. But in practice, the Supreme Court is treating them as precedential, and lower courts are starting to treat them as precedential on their own as well, like you saw in that Georgia re, redistricting case. It acted on its own. In Tandon, like I just said, Supreme Court chastised the Ninth Circuit for not following its earlier rulings on the court's shadow docket. And just recently in Trump v. Boyle, another shadow docket case, the court said this was resolved by a shadow docket order in Trump v. Wilcox. Um, it said in that these orders are not conclusive as to the merits, but it should inform you. So actually, you do need to follow it, or we will chastise you like we do the Ninth Circuit. Um, so we're kind of stuck in that land of this is what's happening. So I think taking all of these together, how do we as practitioners react to this? And really what's happening is traditional equities balancing for emergency applications isn't really what the Supreme Court is focusing on anymore. They're looking at, the merits in these shadow docket decisions. And so as practitioners, I think it's important that we think about, not just looking at the equities, but also making sure we're showing, likelihood of success on the merits. Making the arguments for why you're entitled not just to that relief, but why you really should win. And it's likely that courts are going to begin to do the same in response to the Supreme Court, showing that that the merit analysis also leads to the same result. And trying to provide the Supreme Court justices with some reasoned judicial analyses of issues. On the last slide here, I have a bunch of resources. There are a lot of these resources are tracking the shadow docket decisions. And I would say it's really important to start thinking about actually checking these. How, even if it's just 1, 2 sentences being sent down, a paragraph, that ultimately is having an impact on how the lower courts are acting, and it is instructive. And so when we're looking at our cases, and often we're really focused on on the merits opinions, that's how we were trained in law school, and we get really we focus in on those, rightly so. Um, but given what's happening on the shadow docket, it's really important to be watching the series of decisions that are being made. One on their own, as I hope that I kind of pointed out, one on their own isn't it's not enough. It's about kind of how they're treating things as a whole. And you'll see in these different areas of law, you're starting to see these shifts, these procedure shifts. And now also, even substantive law changes. Um, and so there's some resources here that are wonderful trackers that I would suggest, you look at and think about in your cases that some of these changes may not be showing up in merits decisions. It's more about what's actually happening in practice when you look at a line of cases. How are shadow docket, decisions not even related to you? If you're in California at a shadow docket, case about COVID restrictions in New York, that were very specific, okay, that might be suddenly relevant, even though we may not think of it that way. So I would utilize these resources. Um, I know I went right up to time, which doesn't leave a lot of time for questions, but I will peek in to see if there are any. Um, and otherwise, I will send out kind of the recording, follow-up materials as well. Um, um, as well, I'm looking at some of these. Uh, whether you can have friends of the court briefs there's a question here about whether you can have friends of the court briefs in shadow docket cases. Um, it seems like kind of a mixed bag from what I've seen. I think it's not necessarily like traditional practice. Remember, you're not even getting full briefing. But I think as practitioners, it's worth thinking about what you're asking for, thinking about these questions actually strategically, because yeah, you might be having a merits analysis um, in your emergency application. Um, so I think all of this is just, as practitioners, we have to think about this in ways we haven't before. We have to understand that we're not operating on traditional procedure for emergency applications. Suddenly your merits are relevant. It's not about, a balancing of the equities. So how are you addressing that? And I think all of us as practitioners just have to begin to actually think about this beyond just we're very all focused on our own individual cases or our own area of law. Um, but the whole practice is changing. And so I think the first step is probably awareness, and then to begin to think about how can you try new things? Um, what can you make sure, that your district court judge gets into their decisions that might help if you end up in the Supreme Court, that you have some merit in there. And that I think that's different. And so I'd say the first step is really to just be thinking about these things broadly. I don't know if that answers that question perfectly. Um, there's a comment in here that says we should challenge the shadow docket by forcing it to describe why it warrants precedential value without reasoning. Yeah, I mean, absolutely, right? We should be challenging that. Why is that acceptable? But that requires us to be really aware of those things, thinking of those things, um, and analyzing it as a whole. Um, and and with that, I think I'll wrap up. I hope this was I don't know, fun's not the right word for this. It is what it is. We're gonna take it, but maybe a less in the minutia CLE training. Thank you so much, everyone. I appreciate you being here. And if you don't hear from me in about 2 weeks, please definitely reach out. Thank you.